From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court takes up a case on the Seventh Amendment, which could be a big ruling for the future of the administrative state. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. On Wednesday, the justices will hold oral argument in a big case on the Seventh Amendment. No, not the Second Amendment. That's the well-known right to bear arms. We're looking 5 amendments down, lucky number 7. And here it is. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. And this is at issue in a case called SEC versus George Jarkesy. It involves an administrative law judge ruling that Mr. Jarkesy had to pay a penalty of $300,000 under the Securities and Exchange Commission's rules. Alicia, can you give us some more background of this case and why it could be a big one for the administrative state and all of these other agencies that populate Washington, D.C.?
So the SEC brought this case actually originally in 2013 against the hedge fund funder, George Jarkesy, for securities fraud, like a garden variety securities fraud case. I mean, the agency brings dozens of them a year. But actually, shortly beforehand, in 2010, the Congress passed the Dodd-Frank Act, which actually allowed the SEC its choice of forum and how to bring cases. So previously, it was actually required, at least in some cases, or in most cases, to bring cases in federal court. And usually the defendant in that case would be able to choose whether it wanted to waive a right to jury or not. Here now with the Dodd-Frank Act, the commission could decide to bring enforcement actions in its own internal tribunals, or if it so chose, also go to federal court. So it actually had its choice. And as you might imagine, it has increasingly decided to bring cases in its own in-house tribunals. And essentially how this works is the SEC enforcement staff essentially act as prosecutors, and they bring an action, they charge an individual. And again, these don't actually have to be anyone who is licensed with the agency or as actually it had been in the past too. They could be any individual and any Joe on the street could be charged with insider trading or fraud. And then administrative law judge, which are these essentially just government employees with a legal background. They review the evidence that is brought by the prosecution. And the defendant really doesn't have a lot of due process rights. They can't really depose the SEC or subpoena a lot of information and go through all the discovery processes that they could in a federal court. So the SEC is able to essentially admit all kinds of hearsay, unauthenticated documents that also wouldn't be admissible in federal court. Then the ALJ reviews all the evidence and then issues a decision. And then after the decision, the SEC, in most cases, rubber stamps the ALJ's opinion and decides essentially the sentencing, what the punishment will be. In this case, the ALJ, no surprise, actually ruled against Mr. Jarkesy. And then the SEC, 6 years later, issued his punishment. And there's a little bit of irony to that because these administrative tribunals, the reasons why they were initially set up was because they were supposed to be a faster way to mete out justice and to punish misconduct. And of course, this case has now dragged on for now a decade. Then in any case, Mr. Jarkesy, he was not just fined, but he was actually barred from the securities industry. And then he appealed to the Fifth Circuit, actually bringing constitutional challenges to the way these administrative tribunals are set up, namely that they violate his right to trial by jury under the Seventh Amendment, and also that these administrative law judges who hear these cases they violate the Constitution's take care clause that essentially the Supreme Court has interpreted to require the president to be able to remove inferior officers of the United States in the executive branch by will, rather than these removal restrictions for ALJs, or they can only be removed for cause, which is basically malfeasance or neglect of duty. And so there's basically a separations of powers challenge also in this case.
Kim, the other thing that comes to my mind here is this issue of separation of powers. I'll read just a piece of Mr. Jarkesy's brief and paraphrasing some legalese here. In 2010, a section of the Dodd-Frank Wall Street Reform and Consumer Protection Act granted the SEC the authority to seek penalties administratively against any person for violation of the securities laws, including for the traditional fraud claims codified in statute. And Kim, so what you end up having here is you have the SEC as the enforcer of these laws, and those claims are then adjudicated by SEC in-house judges. And I can only imagine that when there are gaps or ambiguities in those laws, the SEC, like other agencies, does rulemaking in order to clarify ambiguities or fill gaps and explain exactly how it intends to enforce the laws. And so, Kim, what you end up with is exactly what the founders were warning against, is legislative, judicial, and executive power being exercised in the same building by the same group of people.
Yeah, let's think about that just a little bit more. So as you say, all of this is in-house. Now add to this the unfairness of the fact that these administrative tribunals also have all kinds of rights and privileges that they can use against the defendant here that would not be allowed in a federal court. So, for instance, they can use hearsay evidence. They can use unauthenticated documents. By the way, in the Jarkesy case, the SEC staff was found to have improperly accessed privileged legal memos, which they would not have been allowed to do in a federal court. There are also fewer procedural protections for the defendant, limits on their ability to, for instance, engage in discovery and find out what their accusers and prosecutors are doing or get a hold of information that might be helpful to their case. And by the way, if you're wondering how much this stacks the weights on behalf of the SEC, in the year that the Jarkesy administrative trial was heard in 2014, the SEC won 100% of its cases. So I think we can assume that things are certainly rigged in a certain favor. This compares to 61% of cases that the SEC won if they went to federal court in a contested case. So you have all that going for them. And then there's nothing you can do, as the Jarkesy lawsuit notes, to get rid of these folks. The administrative law judges here can only be gotten rid of for cause, meaning the president can only remove them if they've done something very bad. And you have to show that that's the case. So they're insulated in that regard. Another separation of powers issue. And they, meanwhile, are chosen by this merit selection review board, the members of which can only be removed if they are shown to be inefficient or engaged in malfeasance or are neglecting their duty. So you've got these two layers of these entrenched individuals who can never be taken out of the SEC, allowed to use all these tools that would never be allowed to be used in a federal court system, all of this happening in-house. I don't see how anyone can argue that this is a straightforward or fair representation of justice. And that is why it's really good news that the Supreme Court is taking this up.
Alicia, another piece of the argument here involves what are called public rights. A section of the SEC's brief, it says an agency adjudication complies with Article 3. That, of course, is the constitutional section setting up the courts, and therefore with the Seventh Amendment if it involves public rights. So what do you make of that argument, and what is the distinction being made here legally between public rights and private rights?
Oh boy, we could probably have a 3-4 hour law school seminar on the distinction between public and private rights. And there's actually a fierce dispute even on the Supreme Court about how do you distinguish between the two. And there have been a number of cases. And that's how the SEC tries to actually hang its argument. And it wants to essentially write a very expansive definition of public rights, and such that it's anything whenever the government wants to enforce a law or take an action on behalf of the public that is therefore a public right. Now, the Supreme Court has never actually adopted such a sweeping definition of the public rights doctrine. And I think that in this case, Mr. Jarkesy is arguing for much more narrow interpretation, and that is that the public rights essentially only apply to, government granted privileges, franchises, licenses, benefits, and such. It's not necessary for the Supreme Court to actually distinguish between public and private rights to actually decide this case, because Mr. Jarkesy makes kind of an originalist argument that anything that was kind of understood at the time of the founding, common law claims were to be held in a federal court and to be heard by a jury. Now, common law claims, fraud is a quintessential common law claim. There are other torts. Just because the SEC is prosecuting fraud, supposedly on behalf of the public, its claim is that Mr. Jarkesy was defrauding other private individuals, and the SEC is now trying to actually deprive him of his own core private property rights, which is essentially the $300,000 penalty. So there are actually private rights at stake here.